Hi, and welcome to jury charge tonight. Jury charge practice. We're going to do 5 minutes at 200 jury charge for practice. Ready? At various times in these instructions, I will use the term burden of proof in order to inform you which party has the burden of proof on a particular claim or a particular issue. The party who has the burden of proof on a particular issue has the burden of establishing his position on that issue by a preponderance of the evidence. If you conclude that the party who has the burden of proof on an issue has failed to establish his position by a preponderance of the evidence, you must decide against that party on that issue. What does preponderance of the evidence mean? A fact is established by a preponderance of evidence when it is shown that the fact is more likely true than not true. Preponderance of evidence means the greater weight of the evidence. You are to determine whether a fact is established by a preponderance of the evidence on the basis of the quality and persuasiveness of the evidence, not on the basis of the number of witnesses or exhibits. In determining whether a fact has been proved by a preponderance of the evidence, you should consider all of the relevant evidence. You should consider the relevant testimony of the witnesses, regardless of which party may have called them, and the relevant exhibits received in evidence, regardless of which party may have introduced them. What if you find that the credible evidence of a particular fact is evenly divided between the parties, that is, equally probable that one side is right as it is that the other side is right? In that case, you must decide that issue against the party who has the burden of proof. This is because the party who bears the burden of proof must establish more than equality of evidence. He must prove that fact at issue by a preponderance of the evidence. The party with the burden of proof, however, is not required to prove the elements of its claim by more than a preponderance. As long as you find that the balance tips, however slightly, in favor of the party with the burden of proof, so that the fact that party must prove is more likely true than not true, that fact will have been proven by a preponderance of the evidence. You may have heard the phrase, proof beyond a reasonable doubt, which is the standard of proof required in a criminal trial. That requirement does not apply in this case, which is not a criminal case. Plaintiff Kenneth Parker asserts a claim against Corrections Officer Frank A. Rita, Charles Harrison, Barry Norfleet, and Sergeant Robert Cruson under a federal civil rights law, 42 United States Code, Section 1983. The statute provides a remedy for individuals who have been deprived of their federal constitutional rights under color of state law. Section 1983 states in part that every person who, under control of state law, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the United States Constitution and federal laws shall be liable to the party injured for damages. Section 1983 creates a remedy for people who have been deprived of rights secured to them by the United States Constitution. It was passed by Congress to enforce the 14th Amendment of the Constitution. The 14th Amendment provides in relevant part that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 1983 itself does not establish or create any federally protected right. Rather, it allows the plaintiff, in this case Mr. Parker, to enforce rights guaranteed to him by the federal Constitution. Later in these instructions I will explain to you what these federal constitutional rights are and what Mr. Parker must show to demonstrate a violation of these rights by the defendant corrections officers. To establish his claim under Section 1983, Mr. Parker must demonstrate by a preponderance of the evidence the following 3 elements. First, that the defendant corrections officer's conduct was under color of state law. Second, that this conduct deprived Mr. Parker of a right protected by the Constitution of the United States. And third, that the corrections officer conduct was a proximate cause of the injuries and damages sustained by Mr. Parker. I will explain each of these elements to you. First element, color of law. As to the first element, whether the corrections officers were acting under color of state law, that during the events at issue here, the defendants as corrections officers working at Sing Sing State Correctional Facility were acting under color of law. Therefore, you will not need to concern yourselves with this first element of Mr. Parker's case. Second element, deprivation of a federal right. The second element of Mr. Parker's claim is that the corrections officer's conduct deprived him of a federal right. Mr. Parker claims in this case that he was deprived of his right to be free of cruel and unusual punishment under the Eighth Amendment to the Federal Constitution. I will explain later in these instructions what Mr. Parker must prove in order to establish that he was deprived of his Eighth Amendment rights. Third element, proximate cause. The third element that Mr. Parker must prove is that the defendant's conduct was a proximate cause of plaintiff's injury and damage. Under Section 1983, the defendant's corrections officers are responsible for the natural consequences of their actions. An act is a proximate cause if it was a substantial factor in bringing about Mr. Parker's injury. Sorry about the dog.